I'm Russ Feingold. I'm lucky to be the president of the American Constitution Society, and I want to thank you for joining today's program, Reckoning with the Constitution. We at ACS are now celebrating our 20th anniversary year. And since we are called the American Constitution Society, we thought it was more than appropriate that we take this opportunity to especially focus our attention on some of the central challenges presented by our founding charter. This is our organization's central theme for 2021 and beyond. We see this as starting the dialogue in a systematic way about the fundamental problems involving race with our Constitution. And this, of course, is in part because of the events of last year. A question being asked once again by many in response to the past year's events is, why should somebody revere a document authored by slaveholders that, while beginning we the people, explicitly counted slaves as 3/5 of a person and excluded Native Americans and other indigenous people and women and many others in its definition of the democratic polity? And as we continue to grapple today with the legacy of slavery, what accounts for the obvious failure of Reconstruction? Was it a matter of implementation, or was there a flaw in its design? And ultimately, as we go through these programs during the year, we want to think about how we can reconcile the Constitution's aspirations and our continued reverence for it with its central failings and contradictions. Just think about the right to vote. How is it possible that we can live in a country where Shelby County decision comes down after the way African Americans have been treated in terms of the right to vote, and somehow it helps launch an awful era of repressing the African American vote? And even today, in front of the Supreme Court, Native Americans are facing a possible decision that will make it much harder for people that are spread out throughout a region in Arizona from being able to simply collect absentee ballots and vote. So this is the current reality of what has been a problem from the beginning. These are questions that must be meaningfully addressed if we are to put an end to the scourge of racism that has infected our society. And we here at ACS intend to play our role in doing so. Throughout the year, we will be holding programs at both the national and chapter level on these themes and asking, how can we use law and policy to help us arrive at a third Reconstruction? And I believe, as we continue our preparation for this, that it is time for this country to seriously think about having something along the lines of a real truth and reconciliation process and commission. Because somehow, even though other societies have dealt with their fundamental flaws, this society really has not. And we will be talking about and be interested in your ideas about how we should go about that in the coming months. We hope you'll join us in that endeavor. I want to really thank such a fantastic group of panelists in advance. And I want to especially thank Zanelle October, our Executive Vice President, who you'll be hearing from at the conclusion, for really helping drive this initiative of this theme for this year on this incredibly important topic. And now I'd like to turn it over to my colleague, Lindsay Langhals, an ACS Director of Policy and Program, who will lead our discussion today and introduce our illustrious speakers. Thank you very much.
Thank you, Russ. A few housekeeping notes just to get out of the way before we get started. First, please note that today's call is being recorded and the recording will be available on our website, acslaw.org. Second, if you'd like to ask a question at any time during the event, please type it into the Q&A box on the bottom of your screen. We'll be taking questions after our presenters are finished with their initial remarks, and we'll try to address as many as possible. If you are a member of the media, please include your outlet with your question. Finally, 1.25 hours of California CLE credit is available for this call. Please email us with reckoning in the subject line at info@acslaw.org to receive your certificate. If you are seeking CLE credit in a jurisdiction other than California, please consult the rules of that state's CLE board to see if it provides reciprocity with California. CLE materials can be found in the event page of the ACS website and will also be shared with all participants in a follow-up email. We are so lucky to have a team of experts join us today, and we have so much to cover, so I'd like to jump right in and first introduce Professor Randall Kennedy, who is the Michael R. Klein Professor at Harvard Law School, where he teaches courses on contracts, criminal law, and the regulation of race relations. He served as a law clerk for Justice Thurgood Marshall of the U.S. Supreme Court and Judge J. Skelly Wright of the U.S. Court of Appeals for the District of Columbia. He is the author of numerous books and scholarly articles, including the forthcoming Say It Loud on Race, History, and Culture. Professor Kennedy, I'd love to turn it over to you to help us set the table for this conversation.
Thank you so much. It's a real pleasure to be here, and I'd like to thank everyone who has pitched in to make this forum available to all of us. So our subject is reckoning with the Constitution. I'm happy to address this question. I put happy in quotation marks because, colleagues, we are in a moment of real peril. I have never felt like this in my life. I was born in 1954 in Columbia, South Carolina. I've seen a lot of things, but I have never felt more trepidation about the state of our polity, our democracy, than now. I feel tremendous concern. Concern's too pallid a word. Frankly, I'm fearful. I'm fearful of the future. Why? Well, not so long ago, there was a national election. And in the weeks prior to that election, there were very serious people who were talking openly about whether there would be a handover of power. For the first time in my lifetime. You might recall there being editorials in which all the living secretaries of defense got together, wrote a letter, open letter, reminding the military of their place, stand down. Well, they were provoked to do that because of fear of just the opposite happening. So, at the most fundamental level, we are in a moment of tremendous crisis. I feel somewhat relieved that the electorate prevented us from suffering just immediate, utter ruination. I feel some degree of relief, but frankly, not a whole lot. Not a whole lot of relief. I think there is still reason to be very deeply concerned. After all, the former president of the United States has unleashed a lie that lots of Americans believe in. And so the whole question of the legitimacy of the current regime has been put in question. The former president of the United States, Donald Trump, who in the most ostentatious way showed his racism, showed his cruelty, showed his deceitfulness, showed his absolute utter contempt for democratic procedures, democratic ethics. After showing that, he still got over 70 million votes, and is still a quite formidable power in American politics. That is what is overhanging us. And that's why I think we really do have to talk about reckoning with the Constitution, because our Constitution is part of the problem. I know, there's the American Constitution Society. I think that the Constitution of the United States has some good features, but it also has some awful features. And I think we really do have to get rid of an undue veneration for our constitutional regime. The Constitution of 1787, of course, the Constitution of 1787, ambiguous document, but certainly a big part of it was an unspoken embrace of slaveholding. And I'm not going to go into that a whole lot. I mean, it seems to me that's so obvious. Was it ambiguous? Yeah, it was ambiguous. That's why the great Frederick Douglass could, in the matter of in a decade, go from wishing to overthrow the Constitution to embracing the Constitution. So there was some ambiguity, but at bottom, it was a slaveholders' Constitution. And it had features in it that are still very much haunting us, including, I mean, we've never really torn up the roots of slavery. That is still a problem in our country. It's offshoots, it's evil offshoots, but there are other problems as well. 1787, the Senate, malapportioned, something that we're suffering from. The fact that you can have a state like, let's say, Idaho, have as much representation in the Senate as a state like California, despite the tremendous difference in population, that's a real problem that's facing us. The Electoral College. And then another one, natural born citizenship. To be president of the United States, you have to have been born in the United States. That is to say that the millions of people who are naturalized citizens of the United States are not eligible to be president of the United States. That is an invidious discrimination in the heart of our Constitution. And of course, the former president, Donald Trump, that is one of the birtherism is what helped put him in the White House. This is, as far as I'm concerned, no small thing, and we should attend to it. That's the Constitution of 1787. Let's go to the Constitution of 1865 to 1868. The Reconstruction Constitution, the Constitution of the 13th Amendment, 14th Amendment, 15th Amendment. Those amendments did represent a tremendous step forward, no two ways about it. The second founding. But again, we shouldn't venerate. Let's take the 14th Amendment. The 14th Amendment quite clearly permitted disfranchisement. The state had to pay for disfranchisement, but the 14th Amendment permitted racial disfranchisement. So much so that there were some champions of racial justice who repudiated the 14th Amendment. The two Black members of the Massachusetts legislature voted against the ratification of the 14th Amendment precisely because the 14th Amendment permitted permitted racial exclusion at the ballot box, winked at it, made states pay a price for it, but did not take steps to prevent it. 15th Amendment, really quite remarkable, but of all of the provisions that were being discussed at the time to permit, to exclude racial disfranchisement, the 15th Amendment was the narrowest. And there were people in 1870 who said, well, you don't have to be all that smart to figure out ways to get around the 15th Amendment. I mean, literacy, property, there are all sorts of ways that you can get around it. But those who had the political power, because they wanted to actually exclude other people. They wanted to exclude people from overseas. They wanted to exclude new immigrants. They didn't want a powerful enfranchising provision. They wanted something rather weak, and that's what we got, and that's what we still have. Let's jump to the second Reconstruction. period between approximately 1950 to 1970. There's so much there. I don't want to go on forever. I'll just say one thing. The high point of the Second Reconstruction, was the Voting Rights Act of 1965. Well, we've seen the Voting Rights Act of 1965 eviscerated by our present Supreme Court, and it might be even nullified even more. We need to think about constitutional change, because if we don't, we are going to rue our complacency. If we don't have constitutional change and major constitutional change, we are going to suffer further degradation of our democracy. So as far as I'm concerned, with respect to the Constitution, we need to rethink all of it and not be afraid to reconsider all aspects of our constitutional system. We need to do that, and we need to do that with a real spirit of urgency. Thank you very much.
Thank you so much, Professor. I want to bring in Tiffany right next. Tiffany is an adjunct professor and supervising attorney for the Howard University Civil Rights Clinic. She is also a senior associate in the DC office of Orrick, Harrington, and Sutcliffe. She served as a law clerk for Justice Sonia Sotomayor of the U.S. Supreme Court, Judge David Tatel of the U.S. Court of Appeals for the District of Columbia, and Judge C. Lamberth of the U.S. District Court for the District of Columbia. She got the full range there. Tiffany, I would love it if you could help us bring some of this history that Professor Kennedy was talking about to the modern moment that we're in, and just the different ways in which we are seeing this problem manifest itself.
Sure, and thank you for having me. Very happy and honored to be here. So in so many ways, as Professor Kennedy was just saying, we are a product of choices and compromises made hundreds of years ago. And the remnants of slavery and Reconstruction are visible in nearly all aspects of our life, from healthcare to education, from entertainment to property ownership. And we could probably spend hours just talking about that. But for present purposes, I think I will focus on two. Both involve the political rights and specifically representation of persons convicted of crimes. And bear with me, because in order to explain how we got here, I have to revisit the past just a little bit. So first, the disenfranchisement of felons. One of the rights most desired by formerly enslaved people during Reconstruction and most resisted by white Southerners and white people generally was the right to vote. And the battles fought over the right to vote and the compromises made continue to affect us today. And how we got here is really a compromise made by the Republicans who controlled the 39th Congress. And they had a dilemma. So the emancipation of slavery threatened to change the balance of power in the House of Representatives. Once free, the Constitution, of course, required that freed men be counted fully for representation purposes. But at the same time, none of the Southern states permitted Black people to vote. So without some action from Congress, emancipation would have the perverse effect of increasing the political power of white Southerners who had just led the succession that devastated the country in the Civil War. So they had two options. One was to limit Southern representation, which, while perhaps justified in the aftermath of the war, was not a long-term solution, or they could have ensured that formerly enslaved Black citizens would have the right to vote. The problem with that second option was that it just wasn't politically palatable to have, as Professor Kennedy was just explaining, a robust commitment to the right to vote, particularly for Black people. So the compromise was Section 2 of the 14th Amendment. Section 2 provides that representatives shall be apportioned among the several states according to their respective numbers, but when the right to vote is denied, the basis of representation shall be reduced, except when that denial is for participation in a crime. So Section 2 explicitly provides for the denial of the franchise of persons convicted of crimes. And what we saw in the immediate aftermath of this, that Southern states, in addition to waging a campaign of violent terrorism against Black women and men, also became intent on criminalizing Black people and took full advantage of this constitutional license to disenfranchise persons convicted of crime. And so a good example is Alabama, which in 1901 amended its constitution to require the disenfranchisement of all persons convicted of crimes like miscegenation, explicitly racist, crimes against nature, and a catch-all, any crime involving moral turpitude, which was interpreted by the Alabama Supreme Court to be anything that's immoral, whether it's a crime or not. And so in adopting this provision, Alabama lawmakers were explicit in their purpose, which was, according to one lawmaker, to establish white supremacy and to maintain it in the state. Now, the Supreme Court struck this down in 1985 in Hunter versus Underwood, but there were many states that took a less explicit route to disenfranchising people convicted of crimes that has a disproportionate effect on Black people. Today, 2.2 million Black Americans cannot vote because of past criminal convictions. That is 1 in 13, 4 times the rate of all other racial groups combined. In 23 states, including Alabama, at least 5% of the Black voting age population are banned from the ballot box. And this is, to be clear, not because Black people commit more crime. That's not it at all. We know that white people commit crimes at the same or higher rates. And states have been particularly resistant to changing this policy, despite the clear racial disparity and despite overwhelming popular support for a change. And we saw this recently with Florida. While the 65% of Floridians wanted to get rid of felon disenfranchisement and voted for it, the Republican legislature and the governor came in and said, well, you still can't vote if you can't pay all of the fines attached to your conviction, even if you don't have the means to pay. And so that's one thing. And the second way that we see the current effects of compromises and choices made during Reconstruction is prison-based gerrymandering. And so one effect, of course, of the 3/5 compromise was that populations of enslaved people were used to increase the political power of white people who denied them their personal sovereignty. And so in this way, American chattel slavery permitted white people to not only profit financially from the labor produced by Black women and men, but also to profit politically. And of course, the 13th Amendment abolishes slavery and involuntary servitude, but permits involuntary servitude to the extent that it is a punishment for crime. So here again, we see this explicit exception for those considered criminals. And we have the immediate attempt during Reconstruction, and really it started before, to make Black synonymous with criminal. And it's around this time at the turn of the century, we see America's first prison boom, because there were crimes invented solely to target Black people, things like not showing respect, not getting out of the way when you run into a white person on the street. And states began something called convict leasing, where the state could lease out Black people who were imprisoned, and they found themselves living like slaves in another form of slavery for many years after the Civil War. The treatment of these people was horrific. Texas had to outlaw the practice after the death toll became too high. And this pattern has carried forward to today, where we have offenses that are enforced more often against Black people, despite the fact that, they are committed at the same or similar rates by white people. America contains 5% of the world's population, but 25% of the world's prison population. Black people are incarcerated in state prisons at a rate 5.1 times that of white people. And the treatment, again, remains horrific. Just a few weeks ago, the Supreme Court had to reverse the grant of qualified immunity for officers who forced the prisoner to live in feces of other inmates for several days. And disturbingly, prison populations are still used to increase political power of white communities through prison-based gerrymandering. This means that incarcerated people who are disproportionately minority are denied access to the ballot box but still included in the population count for white districts where they are incarcerated. And so this gives more political power to rural, disproportionately white communities simply because of their residential proximity to a large prison. And it also gives legislators outsized authority based on the existence of Black bodies in their district when they do not represent their interests. And so these are just two ways that I think it's clear that compromises and choices made during Reconstruction continue to affect us and disproportionately affect Black people today with respect to the right to vote.
Thank you so much, Tiffany. I want to turn us now to Professor Mazzoni, who is the Albert E. Jenner Jr. Professor of Law at the University of Illinois at Urbana-Champaign and Director of the Illinois Program in Constitutional Theory, History, and Law. He is a regular media commentator and author, currently at work on 2 books, an overachiever, one on global study of the future of constitutional rights, and the other a study of how the US Constitution serves as both a unifying and dividing force in American society. Before entering academia, Professor Mazzoni clerked for Judge Robert D. Sack of the US Court of Appeals for the Second Circuit and for Judge John G. Kodal of the US District Court for the Southern District of New York. Professor Mazzoni, I'd love to bring you into this conversation to kind of shift us just a bit to talk about the text and the structure of the Constitution itself and what it tells us about this conversation.
Great. So first of all, let me join my colleagues in thanking ACS for organizing the event. It's a great honor to appear on this panel with others whose work I have long admired. So I guess in light of the comments that Professor Kennedy's already offered and that we just heard from Professor Wright, I want to go back to the Reconstruction Amendments themselves. And maybe the first observation is the Reconstruction Amendments are importantly amendments. They are attached to the existing document. So by design, they work in harmony with the existing Constitution, even as they impose change. So you cannot understand Reconstruction without close attention to what is preserved. Federalism is preserved, the jurisdictional boundaries of the states are preserved. Congress gets some new powers, yes, but its powers are still limited, enumerated powers. The 10th Amendment is still in place. The executive branch is retained, unaltered. The federal courts get some additional jurisdiction, but they're still limited. There's no sweeping away of all the prior decisions of the Supreme Court. And the words of the Reconstruction Amendments track and echo and draw on and reinforce the words of the original Constitution in some really important respects. So the no state shall language in Section 1 of the 14th Amendment echoes the language of Article 1, Section 10, limitations on what states can do, with therefore a reinforcement of general state powers unless a power is specifically taken from the states. And framed in the negative, no state shall. No obligation on the part of the states to act, just don't do the things you shall not do, and the Constitution is satisfied. The shall not language of Section 1 of the 13th and of the 15th, same thing, just prohibitions. And then as to Congress, the Congress shall have power language of Section 2 of the 13th Amendment, Section 5 of the 14th Amendment, Section 2 of the 15th, echoes Article 1, Section 8. Power that can be exercised if Congress wants to exercise it, but not an obligation, no duty on the part of Congress to actually take enforcement measures. So it's no state shall in Section 1, but it's not under Section 5, and Congress shall enforce those prohibitions. That's not what it says. So you put these things together, no duties at any level of government on any government actor, and this is reflective of the original design and a function of amending rather than replacing. Okay, so then a few things about each of the Reconstruction amendments, and a little bit of this has been raised in some of the prior comments, but I want to sort of drill down a bit more on the text and sort of linkages among the amendments. So as to the 13th Amendment, this except language in Section 1 is really important. So no slavery, no involuntary servitude, except as punishment for a crime. The text seems to say, or at least some people imagine it to say that, well, even slavery maybe could be punishment for a crime, but at least involuntary servitude can be. And this, of course, as Professor Wright noted, is a huge source of mischief. It encourages a massive use of the criminal justice system to generate convict labor for public projects and leasing of prisoners to plantations and mines and other private operations with generational implications for racial equality. And then Section 2 of the 14th Amendment, because these things are related, has its own except for crime provision. And that links the criminal system and convict labor from the 13th, links it up to voting. This new apportionment formula that Professor Wright just described in Section 2 of the 14th allows the states to deny voting to those individuals the states already had an incentive to convict and punish under the 13th Amendment. So Section 2 of the 14th invites states to expand further their use of the criminal justice system, because aside from convict labor, they can also deny, abridge the right to vote without suffering any penalty in representation. Section 1 is what we focus overwhelmingly on. So I'm glad we've had now multiple mentions on Section 2, right? Section 2 is a provision that says, in contrast to Section 1, which is no state shall, Section 2 says, but the state may do these things. And that has very significant implications for race. Now, think about this also in the context of what Section 2 of the 14th Amendment amends. It amends the original formula of Article 1, Section 2, in which you added to the whole number of free persons 3/5 of all other persons, that is to say, slaves. Under Article 1, Section 2, the states had an incentive to increase the slave population and to report its numbers so as to collect extra seats in Congress. So there's your accounting mechanism. But the penalty provision of Section 2 of the 14th doesn't have anything comparable to promote now racial equality. States have no incentive to report back on the number of individuals who are not allowed to vote. So then who's left to trigger and enforce the shall be reduced language of Section 2? It's an obligation, but it's not directed at anybody. Congress could presumably do it under Section 5, but there's no obligation there specifically. And of course, the foxes, the states, are in the congressional henhouse. And so this representation reduction provision, which could have been a very powerful mechanism, has never been enforced. Okay, and then a couple of other things about the 14th specifically. The Citizenship Clause, the very first thing in Section 1, Professor Kennedy mentioned it. I want to give it a slightly different, say something a little bit different about it. It hasn't received the attention it should. There's an account of this that would say it's a protection against both the federal government and the states, and potentially against private conduct, and potentially imposes obligations upon the states and the federal government alike. But all the activity has been around the no state shall language, which is familiar from the pre-existing Constitution. So maybe there's a reason why we gravitate to that. And it's as though we just skipped past the Citizenship Clause at the outset of the 14th Amendment, Section 1. We sort of pause only to debate whether if your parents are unlawfully present, are you really a natural born citizen? So that citizenship provision has gone rusty. Who knows if you can ever oil it up again and get it going. And then this reference in Section 1 to state citizenship, which tracks provisions of the original Constitution that referred to citizens of a state. So again, this need to harmonize, and is directed at overturning Dred Scott, looking backwards at the same time that you're kind of looking forward. It nonetheless suggests that national citizenship and state citizenship continue on as distinct categories. This is why you get slaughterhouse and its limited idea of privileges and immunities in Section 1. But this also works a reinforcement of state power, because you have this specification now of state citizenship without any defined rights. So the states are going to quickly claim power on that. And then the remainder of Section 1 reinforces the idea that what state citizenship means is under state control, because the Due Process Clause and the Equal Protection Clause apply to all persons. They don't subtract from state power over state citizenship. Now, the 15th Amendment, it speaks back to Section 2 of the 14th. It's the same deny or abridged language in Section 2 of the 14th. And yes, it bars race-based denial of voting, but it invites the states to find grounds other than race on which to interfere with voting. It doubles down then on the except for crime incentive of Section 2 of the 14th, which remains in place unaltered by the 15th Amendment in that sense, and as to which there's no penalty in representation. And when you put these things together, the 14th and the 15th, they invite grounds besides race or crime, so long as you're willing to assume the penalty in representation, and assuming, of course, anybody's paying attention and counting and keeping an eye on what you're doing. So again, 15th Amendment, don't do this one thing, but otherwise you are free to act. And then one more general point about the three amendments together to finish out these observations. If you knew nothing about Reconstruction and you sought to understand it from the three amendments, you'd see that the 13th Amendment eliminated slavery. The 15th prohibited denying voting because you were a newly freed slave or otherwise on the basis of race. But the middle one, the longest, the 14th, says nothing anywhere about race. So the conclusion, again, if you know nothing, might be that as to race, it's just those two things, the 13th and the 15th, and that's as far as Reconstruction on race goes. This has lots and lots of implications. Because the 14th Amendment says nothing about race, it mobilizes lots of other kinds of claims, so that racial discrimination becomes just one claim among many. And yes, this is good for advancing rights and the scope of equal protection for lots of people, but there are some costs. One is that once you allow lots of sorts of claims under Section 1 of the 14th Amendment, courts are inclined to ratchet up requirements of proof and intent and limit the scope of remedies and impose various sorts of immunities precisely in order to limit costs to government and slow down the flow of litigation. Second, once you invite many types of claimants and claims within Section 1 of the 14th Amendment, you dilute or you risk diluting the scope of protection for everyone. Generalizing and nationalizing equal protection and substantive rights with the Supreme Court at the top telling us what these things mean everywhere result in an overall conservative approach. The Supreme Court is not able to tailor its decisions to local circumstances. And the common denominator approach doesn't get at the worst violations. And then once race is just one issue among many, courts have to think about hierarchies of claims. And it's only on that sort of comparative analysis that you end up with the courts making race-based corrections the hardest of all, making it easier for the government to have programs protecting and advancing women, say, or individuals with disabilities, than protecting and advancing racial minorities. Tiers of scrutiny are a product of the multiple kinds of claims the general language of Section 1 of the 14th Amendment invites. And so here's, one consequence. There's a straight line from the generalized universal language of the 14th Amendment to failures of modern education as the means of racial equality, all the way to Grutter. Remember O'Connor telling us, 25 years and everything will be fine. You won't need these programs at the law school level. We're getting pretty close to 25 years, and it does look that, as O'Connor was wrong. And her error is doubly sad because she was right about the importance of law schools and lawyers to democracy. We saw this vividly in the most recent election. And then last point, the slaughterhouse cases, which I suspect many of you don't like, had in my view some moments of wisdom, particularly on the equal protection claim brought. In Slaughterhouse, Justice Miller said, you have to understand the unity of purpose of the Reconstruction Amendments. And so he writes, he writes, quote, we mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made free man and citizen from the oppressions of those who had formerly exercised unlimited dominion over him. And on equal protection, he says, the existence of laws in the states where the newly emancipated Negroes reside, which discriminated with gross injustice and hardship against them as a class, was the evil to be remedied. Now, Miller's wrong, as a matter of text and history, but just as he overstates his case on race, the neutral, universal language of the 14th allows, I think, for understatements as to race today. And that, I think, is a piece of the issue. So I'll stop there, and thank you so much.
Thank you so much. And I want to bring our final panelist in. Luis Ventos-Rauer is the class of 1950 Irvin B. Wells Endowed Professor at the Indiana University Maurer School of Law, where he teaches and writes in the area of civil rights and legal history. He too is a prolific author. His work has appeared in leading law journals and publications such as the Harvard Law Review, Chicago Legal Forum, and the Washington Post. Professor, to bring this home before we get into a cross-panelist discussion, I want to get into what consent of the governed looks like when so many groups were excluded from the constitutional drafting process. I am fortunate to be dialing in from the District of Columbia. I'm a few blocks from the Capitol, which was, as we know, it was built by enslaved people on stolen land. And it really, every time I walk by, reminds me of the conflict of such a revered building and the history behind it. And so I'm hoping that you could speak a little bit to what that consent of the governed problem looks like. And I think you're on mute.
Of course I am. Thank you, Lindsay, for hosting HCS, all of my fellow panelists. This is a sobering conversation, and I hate to tell you, I am not going to make it any better. To my defense, I'm not trying, and it's the topic lends itself to this. So you ask me a great question: what does consent of the governed look like when we exclude so many people from the beginning? Well, as I take your question, I thought about what does consent of the governed look like in 1619? What does it look like in 1776? In 1787? How about 1857, the year of Dred Scott? 1876, the year of Cruikshank. I should add 1873, the year of Slaughterhouse, which is one of my favorite cases for reasons that Jason and I can talk about maybe some other time. How about 1901, the year of the Insular cases? In fact, what does it mean today? Well, to me, it means this today. It means two words: Puerto Rico, or four, to your point, Washington, District of Columbia, or Guam, American Samoa, Virgin Islands, Mariana Islands, and so forth, the territories. So when we think about these places, we think about these major important questions about consent of the governed. The US Constitution, about which you heard before me, and democratic norms. So here's, to me, the takeaway. We're not the democracy that we believe ourselves to be. We are deeply, and I mean deeply, flawed. And so in my time, I want to make 3 quick points, and they'll be quick, and I look forward to our Q&A. The first point, and this is actually curious, the Constitution doesn't explicitly mention a right to vote. I mean, think about that. If you were starting the Constitution today, surely that would be in there prominently. You have, the consent of the governed, citizenship, a right to vote. Rather, our Constitution, for reasons that we can think about, leaves it up to the states to decide who votes and who doesn't vote. I won't say a lot more than that because my time is limited, other than to say that's an odd choice. A right to vote is a negative right. States can do as they want to do, they do as they wish, so long as they don't violate some prescriptions in the text. For example, race, age, gender, poll tax requirement, and so on. And of course, you heard already how those are easily gotten around. And if you wanted to find, I mean, it is a remarkable case to me, the jury trial case out of West Virginia in the 1870s, Straughter, 1880s. The court is in fact saying, I mean, it's an amazing case. The court tells us, look, you can't use race. West Virginia, where you went wrong is you put race on the text of your statute. Rather, if you don't do that, it's a different conversation. It's a different case. And the court went on to tell the states all the things they could do instead of race being used explicitly. It is remarkable, thinking through how states could get around constitutional prescriptions. Well, one thing states also must do is comply with federal law. And most importantly, whatever's left of the Voting Rights Act. And we might get to talk about that, hopefully in the Q&A. That's my first point. Second point, voting is not a right, which is a point we often miss. It's a franchise. And that means everything. And I hope that's been, I know we talk about disenfranchisement, but here, I just want to be really clear. This is what it means, right? Voting is something we must earn as voters, right? We have to qualify. Think about that. It is granted to us. It is not a right of citizenship, right? You're a citizen, ergo you're a voter. Maybe the opposite is true. You're a voter, ergo you're a citizen. But you can be a citizen and not vote, right? That's the point of DC. That's the point of Puerto Rico and the territories. That's the point of course, the 19th century. That's, as I said before, what we talk about disenfranchisement. Right? So just to be clear, here's what that means throughout history. It has meant that you must, for one, own property. That one's gone. Be literate. That one left us. By the way, in 1959, the court said that was a way by which you could regulate the franchise, the Lassiter case. And Congress, 1970, got rid of literacy test nationwide permanently. You must be of good character. And of course, as you've heard, you must not have a felony record. And there's, of course, others. The point is, right, think about that. It's not a right, it's a franchise. And just to be clear, throughout history to this day, the right or the franchise of voting means that you must not live in some parts of the United States, so that if you live in Puerto Rico, you can't vote unless, of course, you move to a state. And if you move to DC, of course, you still cannot vote. That, to my mind, is pernicious. In fact, this is why the idea of a franchise as voting, or voting as a franchise, is why we find ourselves in the space that we do today. So then my third and final point, and you heard this one, and I know you've thought about it, so I want you to think it through with me. How in the world, I hope you've thought about it as hard as others, how in the world is it possible that the 15th Amendment meant nothing? It was a dead letter for 95 years. And that, as we were talking today, as I was listening to my fellow panelists, I thought about the Slaughterhouse cases a lot, which gutted the 14th Amendment of meaning. As a similar point, how do we make sense of those cases? How is that possible? How is it that a Republican court in 1873, by which I mean, right, composed of a majority of Republican justices, takes the crown jewel of Reconstruction and guts it of all meaning? How do we make sense of that? Those are two related questions about the 14th and the 15th Amendment. Well, here's the way I make sense of it. It's about social norms. It's about constitutional norms. American democracy did not wish for African Americans to vote. On a grimy, thin, perhaps useless to them piece of paper, which we call the Constitution, wasn't going to get in the way of what they wanted to do or not to do. And so, of course, African Americans did not vote, and the 15th Amendment had nothing to say about that. And then I want you to think about, to end in a better place, I hope, think about all that took place in order for the right to vote to become a reality, or a partial reality. Here's what I think about. I think about Fannie Lou Hamer. And if you haven't, please do this one thing. This is your homework. Go find her speech at the 64 Democratic National Convention. The speech is called "Is This America?" It's 8 minutes and about 4 seconds. It's tremendous. It will affect you. I think about Ella Baker, activist, NAACP member, helped found SNCC in 1960 and did tremendous work in the cause of racial justice. I think about somebody you've never heard of, probably, Irma Vidal Santaella, an activist, lawyer, and judge who helped Congress draft Section 4E of the Voting Rights Act, which helped enfranchise Puerto Ricans in New York. I tell you these things to help you think about all the hard work that led to the Voting Rights Act. Work, by the way, on the ground, at the grassroots. It's an incredible story. It's tremendous. Incidentally, I am writing a book on that story at the moment with my dear friend Guy Charles, and I can tell you, I mean, it's not incredible, but the kind of work that it took to get us to where we've come today, it's something we don't think about enough, I don't think. So here's the point, here's the takeaway. The 15th Amendment meant nothing until Congress passed the Voting Rights Act, until the social norms shifted on the ground. The act comes to life, and it forces the southern states to comply fully with the 15th Amendment. So here's the point. The way the 15th Amendment came to life was through social norms and through the acts of not only Congress, or the work of Congress, but also the executive and the court. The big takeaway is that Congress led the way, to be sure, but the court also played a really important role in the story. I know I'm telling you this on the day that the court heard arguments in the Arizona cases, which promise yet once again to gut important provisions of the Voting Rights Act. This is almost 8 years after the court decided Shelby County versus Holder, which struck down Section 4B, the coverage formula of the Voting Rights Act. I will not say much more about Shelby County because if I do, one, I will not stop. And you might have to mute my microphone because it might get interesting. That is an appalling case for ways that you may not have thought about, maybe you have. But here's the point. The court is today dismantling the second Reconstruction in front of our very eyes. So the question to me, and I leave you with this, has the norm shifted so much from 1965 to the present? And I don't think so, but if the answer is yes, the question for the future then becomes, how do we shift them back? And with that, I will stop and look forward to our conversation. Thank you.
Thank you so much. Just a reminder for folks to put their questions in the Q&A box. I'm gonna take moderator's privilege to kick us off with the first one, and then we'll dig into those. Louise, you were mentioning the case that was before the Supreme Court today. I'm not sure that everybody on the line is fully aware of the details there. And so if you wouldn't mind giving just a quick description of what's at stake there. But I think as Russ mentioned in his introductory remarks, one of the things in particular that they're dealing with involves voting in Indian country. And so I'm wondering if you could speak to the specifics there as well, and we can open that up to other folks too. But I know Native Americans are in a uniquely situated position when it comes to the consent of the governed question that we were just discussing. So I want to kind of dovetail off your remarks, and then we can move to other panelists.
Certainly, and I'll be really quick. So the point is, by states, which is part of the point that Professor Kennedy was making, this is a perilous moment, unquestionably. We've left voting regulations to the states, which means they play politics with rights that ought to be fundamental, which is why, to my mind, HR 1, and I don't want to keep talking, I can talk about that too if you want, but I'll keep it, I'll let somebody else fill that in. The idea that we need to shift the conversation. Voting ought not be a franchise. It ought to be a right that we owe our citizens rather than things that we extend to them as we decide on an ad hoc partisan basis. So the 33 states are doing this, the last count, basically retrenching voting rights. The cases are in Arizona, and there's two laws. One, which is essentially saying if you come vote in the wrong precinct and you vote provisionally because you're in the wrong place, and then once you voted, you come to find out that you were actually not entitled to vote where you thought you were, they would throw the ballot away, even though some of those races may be statewide or nationwide. So some of those ballots, right, it could be counted because it doesn't matter where you do it. It's not for the local elections that you're voting for. But Arizona says, if you do it wrong, we just throw it out, the whole thing. The second is, and the reason that matters, I'll tell you shortly and quickly. The point you were making about Native American country is that the state has this, what is pejoratively known as ballot harvesting. Go grab people's ballots and then people collect them and bring them to the counting places. Well, states like Arizona, where people live far away, the argument is, look, you need to, and mail is not happening all the time, and you have to travel distances to find places to mail things or to come and vote. The argument is, which makes sense, the idea that you want to make sure that parties, third parties can come and what we call private intermediaries, they come and help make voting effective. You grab the ballot from where it may be, you collect them, and then you bring them to the proper place. Arizona's outlawing that on the argument that what President Trump called ballot harvesting, that you could then allow people to just grab all these ballots and fill them out and fill them as they wish. The laws are striking those down, making those illegal, and the argument is, the response from the Democratic Party was they violate Section 2 of the Voting Rights Act as a vote denial issue, which is it's a new live issue. And so the question becomes, the argument that the fear is, well, Shelby County basically gutted Section 5 through Section 4, the coverage formula, which I can say, I don't want to keep talking, so I won't say anything, somebody will say it. But the point is, in Shelby County, Chief Justice Roberts said, we still have Section 2. Right? This nationwide applies everywhere. Well, the argument now looks like he was never a friend of Section 2 or 5 or the Voting Rights Act in general through his time at the Department of Justice. Well, now the argument is, this is the vehicle through which the court may now come after Section 2 the way it came after Section 4. And the fear, Shelby County is not a well-reasoned case, but that did not matter. Section 2 need not be well-reasoned either for them to strike it down. That is a concern activists have, and it may come to fruition.
I want to maybe just say something very quick about this. I haven't, Louis, I haven't listened to the oral argument transcript. I didn't listen to the recording today's, but maybe kind of two quick observations. One is that we do have 3 new justices who were not there in Shelby County. The Kavanaugh, Gorsuch, Barrett were not there. I don't think we really know sort of what their views are on voting issues. And I would be a bit reluctant to just sort of assume that they, sort of slot in and would hold the same views that of the justices that they replaced and would have voted in Shelby County in the majority, or that they're going to vote to, as you say, invalidate or limit the reach of the Voting Rights Act in the upcoming case. I'm not sure about that, especially given their voting record in some of the cases that came out of litigation efforts over the most recent election, and their disinclination to want the U.S. Supreme Court to get involved. So, you may be sort of right at the end of the day, but let's wait and see. The other thing I wanted to say is that, this sort of, we of course operate, and it's unusual, besides the fact that, as you said, there's no specific provision in the Constitution that says everyone has a right to vote. Our electoral system is highly decentralized, right? Highly decentralized. So state localities are kind of running the whole process, and that, of course, is the reason that Congress, in enacting the Voting Rights Act formula, has to do it that way, because otherwise you can't deal with the problems of disenfranchisement. But that sort of decentralization is not entirely bad. If you had kind of centralized control over the electoral system in this country, the outcome in the most recent presidential election, might have been less clear. If you have somebody who can seize the power at the top, that is a problem when you have those who are not inclined to play by the rules. I mean, federalism and localism in the election was actually the thing, or an important part of the thing, that just shut down the ability of the former president or some future would-be president to just sort of take the reins of power. And so, there's always this kind of question. It does lead to some mischief, maybe at the local level, but let's not sort of forget the virtue of this decentralized process that limits the ability of any one actor at the top to control the whole thing.
Excellent. I want to pull a question from the Q&A that is directed at Professor Kennedy, but then we can pull everybody else into. The question is, what does major constitutional change look like? And they have a follow-up note here that not just maybe passing something to change the text of the Constitution, but with the country as divided as it is, as you mentioned, 70 million plus folks kind of subscribing to a certain view of the country. How do we actually affect that change, and how do we make that meaningful change? And you're muted.
Thank you. I'm not sure. I don't know how one pulls the levers, mobilizes the bodies to do what needs to be done. I would love to talk with person number one, Stacey Abrams, as far as I'm concerned, about that sort of thing. That, I mean, people who know how to move people on the ground, that's very important. That's sort of outside of my kin. I don't know. I do know that that's right. We have a divided country, and so it will be extremely difficult to actually do what needs to be done. And that's why, frankly, I feel that's just another level of our dire situation. If things stay the way they are, if there's a continuing, if government continues to be frustrated, if the needs of people cannot be met, that will actually over time play more and more and more into the hands of those who actually are anti-democratic. That will play into the hands of the next Trump. And so we're in this situation where things need to be done. You ask, what needs to be done? I definitely think that the allocation of power in the United States, we need to take a look at that. I mean, we were just talking about the Supreme Court justices. I mean, if the allocation of power was different, we'd have a different Supreme Court. And if we don't change things, again, if things stay the way they are, we are headed down. So we need to change things. Again, everything, as far as I'm concerned, should be on the table. The Senate, the Electoral College, the whole question of, who can be president, who can vote, all of it. The situation of, the American, the various protectorates of the American empire. You mentioned Puerto Rico, you mentioned the District of Columbia. Places, all of that, as far as I'm concerned, needs to be rethought. One point you asked, Luis, you said, why was it that in the 1880s, Republican justices, and these are people, who had fought for the Union, for goodness sakes, why is it that they were so willing to why was it that they were unwilling to push for a new constitutional dispensation? Why did they go back? I would say they went back in large part because they were restorationists. Yes, they were unionists, but they wanted the old, they wanted the Union like it was before the secessionists fired on Fort Sumter. I think we ought to be very careful about this, because I think now there is, we want restoration. No, we don't want restoration. Trumpism did not come out of nowhere. There was a big problem, and Trumpism is an offshoot of that problem. We should not turn back. There was a problem before Trump. We need to get to higher ground, and we need to get to higher ground in a hurry. How do we do it? I don't know. but I do know that it needs to be done. But we need to get rid of a restorationist mindset and push on to something that is actually more daunting, but more needed.
Tiffany, I'd love to bring you in for a second. You were a co-author of this great amicus brief that really looked at the ways in which civil rights movements, the people who have been on the ground doing this work, and historically, that Professor Kennedy's referencing, have always kind of been portrayed as lawless or, you know, an element not to be trusted with this work. And you really do a great job of, in the brief, of bringing it forward to connect it with Black Lives Matter and the groups that are doing some of this work now. And so I'd love for you to speak to that for a bit.
And so I think our idea when we started thinking about the issue in that brief was a movement by prosecutors and judges to say that folks who support Black Lives Matter are not suitable for jury duty because there is a lawlessness that's inherent in that. And so, you know, whenever I think about these things, I think about the cyclical nature of history of civil rights. And so the very same things, almost word for word, that people say about Black Lives Matter activists now, they said about the folks that were mentioned a few minutes ago who are right behind me here, Fannie Lou Hamer and Ella Baker. They said these same things about them, that they were lawless, that they were rabble rousers, that they were agitators. And so we wanted to make clear that not only are these people suitable for jury duty, but they are the folks who believe so much in democracy and in the way the system should work, that they are the very people that you want on juries, because what would happen if we never had them, if there wasn't a Fannie Lou Hamer or Ella Baker or a Malcolm X or any of these names that we now hold up and say we revere them as civil rights figures. You know, the folks on the ground now, Black Lives Matter activists, are those people for today's generation. And I think that ties into the question that Professor Kennedy was just looking at about how do we get there? And the answer is, I think, engagement and a certain level of courage. What Stacey Abrams did was literally have conversations with everyone that she could reach. And so I grew up in DC, in Ward 7 or the Anacostia area. And I know from talking to my family that there are people who just didn't appreciate the significance of having no representation in Congress. And so once you knock on doors and you have those conversations and you say, this is why it's important to you. If you care about police overreach, if you care about these things, it's important to get involved. And so I think reaching and talking to people that we don't typically talk to instead of always talking to each other, and then acting with some level of political courage, I think is how we get there. And part of it starts with respecting the role and the importance of today's activists.
Excellent. I wanna ask a broader question maybe and get everybody's thoughts, because I know we're running a little short on time. You know, in terms of tactics, I think we just discussed. I want to know what you think the guiding principles should be as we look to make constitutional change, as we look to change our democratic norms. How can we center Black, Indigenous, people of color, and really make sure that those are the groups that are being listened to and at the forefront of this constitutional change? I can cold call on someone if you want me to, but if anybody wants to jump in first, I would love it.
I think we ought to, you know, clearly it's the case that people of color have been historically subordinated, historically marginalized. It's a good thing that there is so much attention being paid to that. Good. It's also the case that, you know, there are a lot of white people in the United States of America. And there is not going to be the sort of change that needs to be accomplished without the support, or at least, you know, without the sympathy, without the support, without the pushing of a wide range of people, including white people. So I would say, you know, we have a very daunting task. At the same time that we have to be very candid, very, you know, just very candid, very realistic about the depth and the power of racism in its various guises in American life. We have to do that. We also have to frame our efforts at change in a way that will bring together a broad coalition of people. And I think, you know, being attentive to that is, it seems to me, absolutely essential. One last point. We've talked, for instance, a good bit about crime, the administration of criminal justice, very central point. A lot of racism, central, no question, both at the street level, the doctrinal level. I mean, race is all over the subject. I do think, however, sometimes that progressive folk are not sufficiently making the point to the public that police brutality, police malfeasance is a threat to everyone, not just people like me, not just Black folks, not just Latino folks, not just Native American folks. You know, there are a good many white people who are beaten up wrongly by the police. There are a good many white people who are shot to death by the police in an unwarranted, completely unwarranted way. And I think it's, you know, we need to make that point. It shouldn't be the case that every trip of the train, every time that somebody's talking about police misconduct, it's a Black person. So, you know, that's a way of sort of ghettoizing the subject, letting somebody, you know, white think, oh, I don't have a dog in this fight. Oh, yes, you do. And so I think, you know, I think we need to be very attentive to making the point. Everybody, I don't care where you're from, I don't care what your race is, everybody has a stake. Everybody can benefit from a better set of affairs in American life where there is fairness. Everybody can benefit. It's not a case that you're going to be down. No, everybody can be brought up. But that's going to require, it seems to me, a lot of thoughtfulness and attentiveness to coalition politics.
Jason or Tiffany, actually you all unmuted. So if you want, like, let's do really quick responses, and then I want to kick it over to Zanel to wrap us up.
I can be really, really quick. Two quick things. One is, of course, there's a distinction between political reform and constitutional reform. So I think, you know, that's something to be thinking about. On the constitutional reform side, I talk to students, liberal students, conservative students. They are unhappy with lots of provisions of the Constitution and how they operate and so on. And so I say, well, how about a constitutional convention? And they always say, no, we don't want that. And so, you know, that's a kind of hard thing to get by. And they don't particularly like constitutional amendments either. So one thing is to be thinking about what sort of political reforms can be achieved, kind of given that you can't probably engage in convention making, can't scrap the whole thing and start over. One reason for that is Article 5 itself. It doesn't actually tell you any of the details about how a convention would be run. And so that's one of the things that gives a lot of people. The other quick thing I would say, and this I think picks up on Randall Kennedy's point, this sort of a conversation that can occur and sort of sharing and identifying of interests across different kinds of divides is something that is essential for any number of purposes. Increasingly, we are polarized. We see things as either you win or you lose, rather than they can be sort of gains for everybody. Our discourse is increasingly coarse, in large part because a lot of it just happens online. We don't pick up the phone. We don't have face-to-face conversations. A sort of recommitment to that, and I think universities are one context in which that can happen and isn't happening in the way that it could be. That might be sort of one avenue as well.
Okay. With that, unfortunately we're out of time. I think we could have stayed with this group for 5 more hours and still not have gotten through everything. I appreciate you all so much. Thank you for such a great conversation. I want to turn it over now to Zanelle October, our Executive Vice President, to wrap us up for the evening. Zanelle?
Thank you, Lindsay, for organizing and moderating this excellent program, and many thanks to Professors Kennedy, Wright, Mazzone, and Fuentes Roa for your insights on this important topic and for getting our national programming on reckoning with our Constitution and examining how law and policy might help combat racism off to such a fantastic start. We cannot remedy our history of slavery, racism, and oppression by ignoring it or downplaying its relevance to our present day. We can and must be able to both celebrate the achievements and aspirations of this country while also doing the hard work of reckoning with and remedying its legacy of racism. I hope all of you on this call will continue to engage with us as we address race in the Constitution going forward. As Professor Kennedy started off, our Constitution is part of the problem. We, together with you, want to get to the bottom of this. So keep your eyes on your inbox and on our website, acslaw.org, for news of future programs and opportunities to get involved all year long. Renew your membership there if you haven't already. We count on your support. Thank you again for joining us today, and we look forward to seeing you next time. Have a good afternoon.